everyone. Welcome to our latest segment of Legal Answers Just for Real Estate. I'm Gayleen Rogers Lonergan. Today I'm looking at three things: what the recent foreclosure data says about Texas and the Dallas-Fort Worth market, and the basic notice and sale rules in the Texas Property Code, Section 51.002, which is the provision that governs Texas foreclosures. Now, this does not constitute legal advice, as always, but just some general information. And the headline is that not every homeowner is in trouble. It's that the foreclosure activity has increased over what it has been for the last few years, which was at exceptionally low levels. But now, with the softer housing market, the activity is picking up. So let's talk about what the numbers show. The numbers are showing that Texas foreclosure starts rose in 2025. ATTOM provide data regarding the most specific data regarding foreclosures nationwide. And it is reporting that 37,215 foreclosure starts happened in Texas in 2025, placing Texas among the highest volume states nationwide. It characterized the national increase as a continued normalization after unusually low foreclosure since the pandemic. Now, don't confuse foreclosure starts with actual sales. Lots of foreclosure starts happen that never go all the way through to sale. The borrower comes up with the money, the borrower sells the property in advance of the foreclosure. All kinds of different things happen that prevents an actual foreclosure from actually happening. Even the broader Texas market softened beginning by the beginning of 2026. A&M reported that the A&M Real Estate Research Center reported that Texas ended the year of 2025 with more inventory, with an average of 110 days on the market and a record 595,370 new listings. Dallas and Fort Worth, however, has been showing price weakness, as most of you that may be watching this know. I hear that all the time from my clients that, well, it's just not selling, Texas A&M reported the Dallas price weakness for 9 consecutive months during 2025. But generally speaking, it's mostly just been flat. So the pressure regarding foreclosures is caused by several things: the continued marketing softening, the rising inventory, and the persistent price pressure. Dallas County, we're lucky as far as those of us in Dallas. The Dallas County website puts online all foreclosure postings that are done for that month online. So anybody that's looking to see whether their property has been posted, what properties are available by foreclosure, all they have to do is go to the Dallas County website and see. Collin County apparently provides a searchable foreclosure notice database, but other counties you may have to do a little bit more research to find out about what's available by foreclosure. So those figures describe the market conditions. They don't replace the legal question as to whether a particular foreclosure was noticed and conducted properly under the way Texas law requires. And again, like I said, generally speaking, Texas law foreclosures are governed by Section 51.002 of the Texas Property Code. In Texas, we are one of the few states that allow non-judicial foreclosure. So as far as lenders are concerned, that is a real plus because they can relatively quickly foreclose on a piece of property that the debtor is not paying, as opposed to the majority of the states out there where you have to go file a lawsuit for foreclosure and it can take several months to get done. Now I'm going to just go through the specifics of section 51.002. It's a public auction. Some people don't, several of my clients were shocked to find that I was going to go down to the designated place in the county and just open up a sale, start reading it out and opening up a sale for bid. That's how it's done. It's required by 51002 that sale has to occur between 10 a.m. and 4 p.m. on the first Tuesday of every month. Now, there are a couple of occasions where that is not applicable. January and July. If January 1st and July 4th fall on the first Tuesday, then the sales are automatically moved to Wednesday. That is a relatively recent turn of events because I have gone down and done foreclosure sales on both January 1st and July 4th, but not since this was passed, this change was passed. The place for the sale is generally the county courthouse steps or in front of the county courthouse, but you need to look online for the particular county to see if the county commissioners have designated a specific place or a place that's relatively near the county courthouse to conduct the sales. That's a must before you even start your process as a lender, is you have to check and see where the sales are actually to be held, and that has to be included in any notices you send. In Harris County, for instance, they now have their sales at this public event center out by the Astrodome, nowhere near downtown, and it is a madhouse. I've been there 2 or 3 times now, and it's just a madhouse. But I had to check and make sure that was the right place, or my sale would not have been valid. You have to send a notice of the sale, and it has to be sent at least 21 days before the day of the foreclosure sale. The day the notice is given counts as counts, but the sale day does not. So you got to make sure you're counting the right number of days so that one day less, your sale can be voided. Then there are 3 required delivery channels of the notice of the sale. Number 1, you have to post in a public place as designated by the county on a board, a public board, the notice, so that anybody going to the courthouse can go look up on the board. Now, there are certain listing services or data services that they employ people to go beginning the day that the posting period ends, to go down and record all of those so that within about 3 business days, then you can purchase a list of everything that's been posted in that county. Second, you have to file a copy of the notice with the county clerk of the county where the property is located. It's not something that gets indexed in the county records, but you have to have filed it with them. Very relatively small filing fee, but make sure you get a stamped copy for your records so that you can prove that you did that. And then the last way is you have to send a written notice by certified mail to each debtor shown in your records who is obligated on the debt. Now, this is another place where there is some confusion. Some junior lien holders think that the first lien holder is obligated to send them a notice that they're foreclosing on the property. That's not true. The only way that a junior lien holder can be legally entitled to receive a notice is if they have entered into an written agreement with the first lien holder that they will send them that notice, and that rarely happens. Also, the guarantors are not required to be noticed. I always do that if I can. If I know that there are guarantors, I always try to send them as well. The more people that know there's a foreclosure going on, in my mind, the better chance of getting paid, which is ultimately a lender's objective. The notice must state the earliest start time. This is something that came, old people like me remember before the late 80s when real estate crashed all over Texas. You could do it anytime. You put your notice between 10 and 4, and you could go anytime. You could go at 10:01, you could go at 3:59. And a debtor that might want to try to buy it there or whatever, want to do something, they had to be there all day long waiting for the trustees to conduct the sale. Well, the borrowers got out and convinced the legislature to make that a little less restrictive and say your notice has to say it's either between 10 and 1 or 1 and 4. So it has to be within 3 hours of the start time you put in your notice. So if you've noticed that your sale is going to occur at 10 a.m., you better get that sale done before 1 p.m. or it won't be valid. Vice versa, if you said 1 o'clock, you cannot start your sale before 1 o'clock. So on days I was doing multiple foreclosure sales, I have come very close to that deadline of 1 p.m. or 4 p.m. But just make sure you do it, and it's always best to find a witness that will sign your paperwork that says they witnessed you do it at so and so time. I try to get that every time. Some of the smaller counties, there's not any witnesses. I'm out there reading it on my own. But if you can find a witness, that's best. Now, if it's the real property is used as the borrower's homestead, there's an additional requirement under 51002. You have to give that borrower 20 days notice and opportunity to cure before you can send out the 21-day notice. So essentially, if you work backwards from the sale date of the first Tuesday, 41 days, you have to allow at least 41 days before you can go to foreclosure. It has to be, that notice needs to be sent by certified mail. The statute specifies how to count the 20-day period. It's similar to the requirements for the 21-day. Mailing, legally significant. Service by certified mail is complete according to the statute when the notice is deposited in the U.S. mail and addressed to the debtor's last known address. So you can, of course, look in the deed of trust, and an address is there. You've also got the address of the property. But if you as a lender know that your debtor moved somewhere else and that's where you've been notified that they are, you have to send it there. I always take the conservative route. I send it everywhere. I send it to the property address. I send it to the address that is in the deed of trust. And if my client has a third address, I send it there. All certified mail. And I get return receipt requested. Also, you can go on the U.S. Post Office website and track the number for the certified mail and print out when it was deposited, when it was scanned, when it was delivered, and I always get that as well. The county records and online notice. The county clerk must make filed notices available for public examination. That's the posting board. They have to prominently post the filed notices that has all of the information on it. Now, this doesn't come up. I can't even think of a time in my career that this has ever come up, but weather and disaster exceptions. If the courthouse is closed because of inclement weather, natural disaster, or another act of God, the filing may occur up to 48 hours after the relevant office reopens. So if the office of the county clerk is closed, you have to, for whatever reason, you have to get it done within 48 hours, and it's still valid. There are some requirements for active military. You have to send them a separate notice. There is a public website for the military that you can check their names and see if they're in active service. I usually do that, have it in my file. So there are some common misconceptions to correct. Foreclosure notice is not necessarily the end of the story. Like I said, that just begins the process and advances it forward. It's not the same thing as an auction or an eviction. It's just that's the first step towards that. The calendar is short, but the timeline has two distinct stages. For a residential home, 20-day notice, an opportunity to cure. You have to tell the debtor how much it takes to cure, and if they do so, that's the end of it. If they don't, then there's a 21-day notice prior to the first Tuesday of the following month that has to be given. The service rule centers on certified mail deposit. Don't be trying to send notices that are not sent by certified mail. That is the quickest way to get your sale voided. So there's some takeaways from this discussion. If you're a borrower, open those notices. I know you want to bury your head and not deal with that, but open every notice that you get and read it. Preserve every default or sale notice. Confirm the address that they used, whether it's the accurate address or not. The relevant dates that it says, the county posting, and any court or bankruptcy filing. And promptly see, if you're wanting to deal with that foreclosure and not just want to let it go, you need to seek out an attorney. In Texas, you need to seek a Texas real estate attorney and see what they will advise you about what you can do. There are lots of things you can do. For investors and buyers, verify the county designated sale location. That is critical. Do that before you ever send any notice, because if you don't put the right place or on your notice, and then you get there on the sale day and it's not there, you can't just go to the other location. That stops everything. You have to restart. You want to confirm what lien position that lien that's being foreclosed is. Lots of second lien holders do foreclosures. And what happens there is if you buy the property, yes, you're the owner of the property, but it's subject to a prior lien. And if you don't pay that, then you're going to lose the property yourself. Verify the occupancy. Is there anybody still living there? Because if they're still living there, count on the fact that they're not going to just move after you buy the property. You're going to have to probably evict them after the sale. If you've zeroed in on a property, you might want to check see if there's any title issues. I have done sales where there were title issues, and at foreclosure sale, everything is buyer beware. I, as a trustee, never advise anyone about the status of the title, even though they ask and ask and ask, and I just make it clear I do not know, and I am not there to advise as to anything to do with the title. So if you have any concern about that, you need to check it yourself before you get there. And then, of course, the possibility of litigation and bankruptcy. There's two things that can happen litigation-wise prior to a sale. A temporary restraining order can be granted, which stops the sale, as long as you do everything you're supposed to do. And let me say, it's key that even if you get a judge to sign a TRO, if there's a bond required, you better pay the bond that day, or that TRO is not worth anything. And unfortunately, I've had clients that were represented by other attorneys that did not know that. And although the judge signed their TRO, they lost their property because a bond wasn't paid for. And then the other thing is a bankruptcy by the borrower. I get lots of notices the day of the foreclosure sale that they have filed bankruptcy. That stops everything. You cannot, there's an automatic stay imposed upon the filing of a bankruptcy. You cannot go forward with your closure. So that's been a surprise to some of my private lenders as well, that now they have to get a bankruptcy lawyer and try to get that deal with them in that bankruptcy. And then for lawyers and real estate professionals, audit the timing, the required notice sequence, the recipient's address information, and the security instruments additional requirements. This is something I can't stress enough. The law 51002 is the basic, is the floor. But if in the promissory note, deed of trust, other loan documents, it requires additional actions on behalf of a lender. Let's say the deed of trust requires, before they can move forward, is they have to send a 30-day notice, not the 20. Well, then you have to abide by the 30-day notice. You need to read those loan documents before you start the process to make sure that you are complying with what is required. If the documents require something more restrictive than 51002, then the loan documents control. If the documents are less restrictive than 51002, then 51002 governs. But that is key due diligence to do prior to starting a foreclosure sale. So, you're going to have to track, if you're interested in properties in the DFW area, you're going to have to track those by county. There's no global DFW area listing. Okay. Even if you subscribe to those services that provide the notices, but that's by county. So if you're interested in a property in Collin County, then you've got to check Collin County or Tarrant County or Denton County. So just be aware of that. So Texas Foreclosure Act, in closing, Texas foreclosure activity is higher than it was during that unusually quiet period following the pandemic. But the most useful information is that statewide, it's not that bad. We are in a softer DFW market, and we are having issues regarding affordability. Everybody knows that. And also there are strict statutory dates and notice procedures. 51.002 supplies the basic public sale framework for the cure notice, the 21-day sale notice, the posting and county filing, use of certified mail, and the first Tuesday auction schedule. And if a specific home or sale is involved, act early if you're a borrower or even a lender. So you need to start, if you get a notice, start dealing with that immediately, because 21 days, even 20 plus 21 days is not that long. So that's kind of an overall framework regarding foreclosures. Like I said, the activity is up. I'm doing a lot more monthly than I had done for quite some time. So if you're if you're a borrower, consult with an attorney about what your options are. There's negotiation is one very real option. But you can't wait until the last week before the foreclosure sale. Lots of people, I hate to say it, bury their head in the sand until it's inevitable, like the Wednesday before the following Tuesday foreclosure. That's almost too late in order to get something done. Certainly by Friday, you're really almost, there's nothing much that you can do at that point. So anyway, I hope this was helpful. It is just kind of an overview of the whole foreclosure situation. And I hope you've enjoyed it and got something useful out of it. Again, it doesn't constitute legal advice. It's just general information. And we will see you guys next time. I'm not sure who my guest will be next time, but we will have, as always, a guest to provide some very useful information. Look forward to seeing you then. Thanks.